amendments 102 and 122, and again let me thank the noble Lord Palmer of Charles Hill for putting his name to these amendments. These are similar to an earlier group that I tabled in relation to Part 1, and it focuses on removing, in this instance, the power of the Secretary of State to make direct deduction orders, and instead suggests that DDOs be only made by the relevant court following an application from the Secretary of State. Throughout committee, the noble Lord Vaux has, I think, very helpfully stressed that when we're having this discussion, particularly in this environment, it's very difficult to imagine anyone other than the noble lady, the Baroness Sherlock, who we do not think of as a malign person. Well, I do not think of as a malign person. This is not helpful in this instance because actually we have to, I think as a committee, always take a decision based on what we think could happen in the future, what governments might, what powers are being created, and can therefore bring to bear our safeguards as much as we can as a committee. I think we can all agree, we keep saying this, but I think it's important to note that we can agree that the powers are in pursuit of a legitimate aim here to reclaim overpayment of money paid to welfare claimants. And following the previous group, we shouldn't say that because a welfare claimant, if they have defrauded the state, can be treated with sort of any kid gloves. I'm not suggesting that. But whenever new state powers are over the individual are created, a legitimate aim is not enough to mean that we shouldn't have a more granular probing of the powers that are being created. Which is why we as a committee, I think, need to insist that powers are tightly drawn to guard against arbitrariness and to limit what's limited to what's necessary and proportionate. So when the government awards itself the powers, as it does in this section, to intrude on the privacy of anyone's bank account, to check on its contents, to remove money, there needs to be a strong legal justification. And as yet, I'm not convinced that we shouldn't make it the job of the courts to best determine and assess when this is appropriate. In an earlier group, the noble lady, the Minister, reassured us in relation to search and seizure powers that we don't need to worry as a committee because this would only happen with court approval. And what I'm suggesting is we might need court approval here. The DWP characterises DDOs as a power of last resort, which can only be exercised where the Secretary of State has given the debtor a reasonable opportunity to settle the debt, notified them of the possible use of the powers, and I did feel that the helpful explanation earlier from the Minister really brought it to life. But on the other hand, there's no definition of, for example, what, quote, reasonable opportunity threshold might be contained within the bill. And ironically, one of the safeguards presented by the DWP are checks on affordability in terms of fairness. This takes the form of account information notices. I know that we're going to have a number of amendments in relation to this, but I do want to dwell on this because these safeguards, I find, are one of the most egregious aspects of this bill. In order to consider whether the debtor can afford to have funds deducted before the Secretary of State makes a DDO, on page 105 in the bill, we're told that he or she, the Secretary of State, must obtain and consider bank statements from the account covering a period of at least 3 months. One requirement of the account information notices is that the bank must not notify the account holder, or anyone associated with the account holder for that matter. This surely, as I've mentioned in previous contexts, puts the bank in an invidious position of being compelled to breach any professional confidentiality it owes its customer, even if its customer is a debtor, based on the word of the government telling them that the account holder owes the DWP money. Compelling banks to hand over bank statements secretly, however benign the motives in relation to affordability checks, and all of that without any external oversight, such as judicial authority, I think needs to be probed in terms of efficacy and ethics, which is what these amendments are trying to do. Before issuing a DDO, the Secretary of State must give the debtor and any joint account holder notice of the proposed order and invite them to make representations, as the noble lady, the Minister, explained to us earlier. On the basis of these representations, the Secretary of State will decide whether and on what terms to make the DDO, and may only do so if satisfied from bank statements and representations that the order is fair and that the liable person, the account holder and their dependents will, quote, not suffer hardship in meeting essential living expenses. Now, that sounds so reasonable, but in reality, it hands extraordinary discretion to the Secretary of State, as there's no threshold to determine what constitutes hardship or essential living expenses, which I'm sure if we went around the room, we'd all have varied versions of what we need to live on and would argue over it. Who decides what's fair in this instance? And I at least want to suggest that having an external court look at this would be more appropriate. Perhaps we might put such qualms aside if these powers only apply to overpayments caused by deliberately fraudulent behaviour. Going hard on fraudsters might well be popular, and I can see why. But these powers to seize funds directly from bank accounts without judicial scrutiny will also apply to individuals who have been overpaid as a result of making a mistake when filling out one of those notoriously complex claim forms, or failing to update changing circumstances, or maybe just struggling to navigate the system in general. And such errors, because that's what they are, account for almost a quarter of overpayments, and they include errors caused by the DWP's own actions, as the carers allowance scandal has revealed. But it's the likes of unwitting carers who will be on the receiving end of these powers. Not all of the people will be will be on the receiving end of these powers, yet negligent DWP staff who've made mistakes are nowhere to be caught by the powers that we're discussing here. And I say this not to have a go at the staff in that instance, but to note, as we've already talked about in a previous group, that we need to not have a one-size-fits-all situation. I think that was the point that the noble Lord Palmer made. I think it's very important. There are all sorts of people that will be caught up. People making mistakes, vulnerable people, and some fraudsters, but they're all treated the same. In terms of recovering overpayments, the DWP has always had the option of using county court enforcement proceedings. This bill wants to cut this out because the DWP argues that the county court method of enforcement is slow and resource intensive. But can I just ask the Minister if it's proportionate that the failure of the state's judicial infrastructure is an adequate excuse for undermining civil liberties? Should it not be a matter of principle that there should be judicial processes in place before the government to take money directly from individual bank accounts, and that if the courts aren't able to cope, that we should deal with the courts, not the individuals losing rights? It's of course correct that it's government and politicians who decide the scope of this legislation, and I'm usually one of those people who worries about the judiciary becoming a barrier to political action. However, when a bill hands over huge powers to the state to, for example, take money that it alone has decided a debtor can afford based on reading their bank statements, and all by bypassing the normal judicial route of using the courts, then I think it's right to query it. Finally, one defence used by the DWP is that direct deduction order powers won't be promiscuously used, as they will be more used as a deterrent to primarily encourage repayment. Indeed, the impact assessment acknowledges that similar HMRC powers to deduct money from bank accounts were only used in 19 out of 22,500 cases evaluated. However, in the case of these proposed direct deduction order powers, the debtor and any joint account holders will already have had their bank statements disclosed by their bank to the DWP before any measurable deterrent effect could be said to apply. And this just seems disproportionate, that the bill gives the government the power to look through sensitive financial information in circumstances where the underlying power is hardly ever expected to be invoked, and before the purported deterrent can even be said to have taken effect. Instead, my proposal is that these amendments will be a deterrent to the government overreaching, knowing that powers will need to gain judicial authorisation, and it might just rein in any cavalier attitudes to matters of privacy and proportionality in relation to welfare claimants being investigated. I beg to move.
Schedule 5, page 104, line 19, leave out the word make and